And it is at the behest of Sanjeev Mukhya, who has not only a history of conducting leaks, he is now a big investor in leaks. Okay? My lords,
That now, Mr. Wood
yes,
has argued.
that he's argued.
Anything else that you have to add?
Please, my lords. The question is, what is the precedent that three of your lordships will hold? Most of the judgments that your lordships have delivered are two-judge judgments. And if your lordships were to be called upon to say that, look, this much of a leak or of a localized leak is not something which we will interfere in, and which we will possibly say, for want of a better term, wink at, then as a lawyer, I might tell your lordships that for the next 20, 30 years, we will be forever striving to say, no, this is not a leak of that kind, this is a leak of this kind, and it is such a small one. So there, my lords, just before I end, my lords, this precedent point came up much earlier, where the argument was made as the solicitors made. And I beseech you, rest once the law to your authority to do a great right, do a little wrong. And Portia's answer was, it must not be. There's no power in Venice can alter a decree established. It will be recorded for a precedent. And many an error by the same example will rush into the state. It must not be.
Yes, thank you, Mr.
I'm
Yes,
grateful.
my lord. I wanted to answer one question of Justice Pardivada and Justice Lordship's question. And when the questions are raised, any member of the bar who was actively participating in the discussion can certainly answer it. And I did not do anything wrong. And I'm sorry, I was unfairly treated. That's a different story. Now, that's a different story. Let me come into the case.
Make your submission.
Coming to the state. Yeah, my lord. Now, I'm amazed by the kind of discussions which has been going on here. We have been conducting a criminal trial. We are going to the niceties. We have called the CBI. But solicit, what kind of discussions which have been going on? The issue is, you ask a common man, a man in the street, there is an examination leak. I came, my petition, I said only one thing. There has been a leak. A leak has been happened, then there is no alternative. There is no alternative than a retest. It certainly leaves inconvenience. Certainly. And only thing that can be thought of is how to reduce inconvenience. And I made a suggestion, which my friend also adopted, that this test be conducted as a NEET preliminary examination. 13 lakh students are qualified. And they be taken for the final examination. And this is an administrative issue. Today, because of PILs, etc., we treat many things which are in the realm of falling in the exclusive realm of governance into the court. And my lord, therefore, this is something the government did a great injustice to the court. The government it was their problem. It was a issue of governance, and the government very conveniently did not raise the maintainability of these petitions. Allowed questions, the detailed arguments to be made for days and days, and they are literally shunning away from their responsibility. There is a government. This is an issue concerning lakhs of people. It is a call of the minister. It is a call of the government, and the government has failed to. I'm not anti-BJP man. In fact, I supported BJP. I advocated for voting for BJP. But what happened today? This is something utterly, I'm not using a very strong expression, unacceptable. The government of the day is accountable to the people. When your lordship, I always say, when your lordship takes a decision, my lord, that only binds the parties before you. When the parliament takes a decision, we are all present in the parliament, and we are symbolically present in the parliament. It binds all of us. In the last couple of years, the governance what the parliament ought to do, what the government ought to do, it is being, the courts are forced to do. Courts are forced to do. Therefore, my lord, the question today is, what is the given situation, what is to be done? Admittedly, there is a leak. And this leaves no option than to cancel the examination, as rightly Justice Vikamnath has said, 0.00% doubt, examination has to be cancelled. And that is the only option. This is a matter which should have been concluded in 20 minutes. And good that we spend a good lot of time. I'm no quarrel about it. And therefore, and my advice to the court is that court should not enter into the domain of the executive. Let the government do its job. Let the government answer to the people. The parliament is going on. Session is going on. The very NEET issue is before the parliament. I'm for the petitioner. I'm strongly advocating the cancellation of this examination. Still, I said, as a matter of principle, a lawyer has to speak about the fundamental constitutional principle. A fundamental constitutional principle is that these are our administrative issues. And if, assuming that the government, at least the matter should have been relegated to the government should have directed to take a decision. And the government, if supposing that the government has taken a decision after hearing both of us, parties affected, not only those who are asking for cancellation of the examination, but also those who are asking for non-cancellation of the examination, because they are the one who stand to benefit by the results. Both parties, to the extent possible, unlike a court, the government is under no obligation to hear everybody. Because the government represents the people, and therefore no obligation to hear everybody. But court, when a court decides a matter, it is under a duty to, my lords, listen to everybody. Otherwise, my lord, that res inter alios acta, altori, noseri, non-debet. Court has no jurisdiction to bind anybody who is not before it. So having this fundamental principle being stated, and whenever every PAL comes before this court should certainly adjust to itself. The people affected are not here, and we don't represent the people of this country. And these issues concerning the public at large cannot be decided behind the back of them. These proceedings are not representative proceedings. These are proceedings, in my case, 16 students were affected by it. Therefore, my lord, when this case came, the only option is to throw the ball back to the government's court, and the government to take a call on the question of cancellation. And the government would have done it in moments' time. It wouldn't have been able to justify this examination, not even one moment. The government would have come with the conclusion, the decision to cancel it forthwith. And the government conveniently, very conveniently, saying that is a non-adjudicatory, the Solicitor General says, non-adjudicatory litigation. What is that? Non-adjudicatory. There is nothing like non-adjudicatory. Court's job is to decide disputes. Court's duty is to decide disputed questions of fact and apply the law. If the issues are non-adjudicatory, there is nothing. It is administrative. And my lord, I conclude by saying one word. My lord, I forgive your lordship for all the insult to me and my lord, humiliation. I forgive your lordship, Lord, forgive them for they not know what they are doing. I have nothing in my mind. I have the greatest of regard for your lordships and lordship Padiwala also. I have the greatest of regard, though I was insulted. I don't keep anything in my mind. But my lord, this NEET examination has to be cancelled forthwith. It cannot be delayed 1 minute, because precious time of the students are lost, and a fresh examination has to be conducted forthwith. And it is for the government to decide whether it has to be for the 13 lakh students who was selected, or it has to be for a lesser number. And these are areas where the court should step in, because what is governing the matters of administration, but those in governance alone come to know about it. Somebody said it's certainly NEET is a very loosely conducted, all outsourced. But that is true. But in a governance, outsourcing is necessary, without which no government can function. Everything, the NEET department cannot do it. So most of the things which my friend Hoda and Sanjay Khadge argued, with respect, I disagree with that. And only my submission is, this is an issue which will be thrown to the government's court. Let them decide. Let them decide. Let the parliament is going. Let them answer to the parliament. And let them not shirk their responsibility and throw all public issues to the court's domain. Because I say so, because average time, which a ordinary litigant who comes for a grievances is 93 seconds. When I come to your lordships for a SLP, it is dismissed in 93 seconds. And I had a recent incident where my SLP was dismissed even 60 seconds. So therefore, we have to revisit it. The PA business has to be discouraged, and only petitions here, at least affected parties are there. My petition is not PAL. My petition is somebody who is seeking declaration of their fundamental rights. And my lord, I conclude, the research has to be cancelled, examination has to be contested. Greatly obliged.
Please, just 2 minutes.
Your Lordships.
Your Lordships asked a question to my learned senior Lords that in this situation, what your Lordships should be doing in case whether the investigation is yet not complete. Because this has been answered in that judgment which I referred yesterday. I just want to repeat a paragraph so that will assist your Lordships. Before that, that Tanvi Sarwal was not cited before your Lordships in the Sachin Kumar's judgment. I tried to check it. That's also a 2-judge bench judgment. This is also 2-judge bench judgment. So this was not cited before your Lordships. That's what I could.
No, but the subsequent judgment which I decided was a case where the government had decided to cancel the entire exam.
So here,
So there was no question of the court being there required to cancel exam. So the legality of the decision of the government to cancel the entire exam wasn't called into question.
Please,
that was
here we are not able to segregate the tainted from the the good people. Just Lordships, you may see paragraph 18. If Lordship wants, I can. Para 18 2015 6 SCC 573. The same situation before your Lordships, as in today. Third line, though as on date 44 such candidates have been identified, having regard to the modus operandi put in place, the number of cell phones and other devices used, it is not unlikely that the many more candidates have availed such undue advantage. So many more.
Para 15 is relevant. Para 15. 1-5.
Let's read para 15 and then.
Yes. The investigating agency in its report has stated in clear terms that from the disclosure recorded, it is beyond doubt that the strategy of providing answer key has been executed by an organized gang with a network spreading over different parts of the country. The Inspector General of Police, who was present in this with his team, having been granted the leave, submitted that the investigation is full swing and in progress, etc., etc. It was their case that it's pan-India.
So, here today the situation is they themselves are saying, that we are yet to investigate further. Now that is also looked into in paragraph 18 if your Lordship sees.
Right, let's see.
Yes, though as on date 44 such candidates have been identified. Having
so the last line he says, frankly, admitted that in process it might not be possible to identify. But it's an all India issue.
Para 18 now.
Yes, para 18, third line, though as on date 44 such candidates have been identified, having regard to the modus operandi put in place, the number of cell phones and other devices used, it is not unlikely that many more candidates have availed such undue advantage being a part of the overall design, and in the process have been unduly benefited qua the other students who had made sincere and genuine endeavors to solve the answer papers on the basis of their devoted preparation and hard labor. In view of the widespread network that has operated, as in this case it appears so, as the status report disclosed, and the admission of person arrested, including some beneficiary candidates, we are of the opinion that in view of the strong possibility of the identification of other candidates as well involved in such malpractices, that examination has become a suspect. As it is, the system of examination pursued over the decades has been accepted by all who are rational, responsible, and sensible to be an accredited one for comparative evaluation of the merit and worth of candidates vying for high academic pursuits. It is thus necessary for all the role players in the process to secure and sustain the confidence of the public in general and students' fraternity in particular in the system by its unquestionable trustworthiness. Such a system is endorsed because of the credibility informed with guarantee of fairness, transparency, authenticity, and sanctity. There cannot be any compromise with this imperative at any cost.
Also,
so, even at the cost of 44 students and a possibility of more people being found, so your Lordships did set aside. The learned solicitor general said 2 lakhs. My information is there were 6 lakh students. This is the same API, All India pre-medical test, the same which was to happen before NEET started. And it is to be conducted by CBSE in that. Yes, Para 19. Segregation only of already 44 identified candidates stated to be the beneficiaries of the unprincipled maneuver by withholding their results for the time being, in our comprehension, cannot be the solution to the problem that contours all of us, that confronts all of us. Not only thereby, if the process is allowed to advance, it would be pushed to the vortex of a litigation pertaining thereto in the foreseeable future. The prospects of candidates would not only remain uncertain and tentative, they would also remain plagued with the prolonged anguish and anxiety if involved in the ordeal of court cases. Acting on this opinion, option would, in our estimate, amount to driving knowingly the students who are not at fault to an uncertain future with their academic career in jeopardy on many counts. Further, there would also be lurking possibility of unidentified beneficiaries of the candidates stealing a march over them on the basis of the advantages availed by them through the underhand dealings as revealed. Having regard to the fact that the course involved with time would yield the future generations of the doctors of the country who would be in charge of the public health, their inherent merit to quality for taking the course can by no means be compromised. So, if even if 10 to 20,000 students come up in the front and I am pushed outside the 1,08,000 milots, ultimately my chances.
Anybody else?
Only one more
Your
thing.
Lordship,
One more thing. Your Lordships, yesterday had indicated the issue which I said was the OMR sheet issue. Your Lordship said it's a personal issue, an individual client. The OMR issue, sorry. In the OMR issue, in fact, it appears to be a part of the systematic failure because it's not only my client, because she has not given she has not been given the OMR sheet. When the OMR sheet, when she got initially, she calculated it came to 650, around 650. But when the result came, it is 103. They have been emailing to the NTA, give the OMR sheet. They have not given till now, So, and others also.
Lordship, my one submission is a very important thing to say. Lordships, then my solicitors and CBI entire focused only here the
Like
Hazaribagh and Patna. Lordship, it is the not focused here the 5 layers scams. Point number 1. Lordships, there is the before of the examinations. Point number 1. It means there is 9 February, 16 months before. Second is Lordships, when notifications came, it means there is the forms, filling forms. It means 9 February to 16 March. In which regions a lot of candidates appeared in the different centers. Next is third layer, see the Lordships, the examination dated, it means the conducting jobs 5 May. 5 May in which regions a lot of candidates, some are the belong from the Odisha to appear in the some other places. In which regions, Lordships, it is the SBI and Canara banks and other types of the issues. It is the not given in the submit is the reports. Third is the Lordship, the after examinations. There are a lot of issues in which regions the 720 marks, which is got by this out of the 720s, 718, 719, 600 and above. And Lordships and others issue the 4 and 6 layers. The Lordship, my humble submissions, please Lordships, on the behalf of the petitioners, Lordships, please reconduct the exams.
My Lord, in item submissions for the applicants in IA number 137554 of 2004. We stand for some of the candidates who have secured high marks. But one submission I would like to make, so far as a leak or theft elsewhere than the 2 or 3 identified places are concerned, I would submit that a decision may not be based on suspicion or conjunctures, because these are all matters to be proved beyond reasonable doubt. I would like to suggest one decision, Lords, AR 1994 Supreme Court 626. AR 1994 Supreme Court 626, where at paragraph 44, the Lordships referred to the Privy Council decision. Of course, it concerned fraud alleged in a civil proceeding. Now, it is held at paragraph 44, my Lords. Mary, in so and so, AR 1941, Privy Council 93.
What is the name of the case?
Lords, it is, Svenska Handelsbanken appellant versus Indian Charge Crop and others.
It was on bank guarantee.
Not bank guarantee. So that's right.
Fraud on bank guarantee.
I only submitted that it concerns allegation of fraud in a civil proceeding.
And that was the reason. You got your point. Thank you.
Proof.
Your Lordships.
One more submission, Lord. One more submission, Lord. So far as the question, the particular question is concerned, eligibility for NEET test is the board examination. The board examination prescribed the NCRT books. And many of the students who are following the NCRT books, which provided both the answers. Therefore, both the answers given by the students are based on the NCRT books, which is the basis for the basic examination for the NEET test. Therefore, they may not be, that question may not be deleted, and therefore the students who gave the correct answer may be given the marks that are due to them. That's all my conclusion.
Lordships, I am
Lordships,
appearing for
in
successful petitioners in IA number 140031.
You don't want a re-examination.
I don't want, Lordships, my humble
How many
submission.
people have argued that now?
One,
How many
Lordships,
people will just because you're for an intervener?
I understand, Lordships. One specific point, my lords. In Tanvi Salwal case, Lordships interfered and cancelled the examination within 45 days. Whereas when it comes to we people, after the result was declared, there was a Rawlsian ignorance, wheel of ignorance, my lords, when it came to the candidates who were involved in Tanvi Salwar case. Whereas in our case, my lords, after we being declared successful, on the basis of a conclusive police report, Lordships interfered in Tanvi Salwar case. Whereas in this case, my lords, police report, CBI report is not as conclusive as what happened in that case, my lords. So we being successful, brought into the rigor of re-examination again, might be, my lords, it may be difficult for us. So on behalf of the successful candidates, I plead, Lordships.
Your Lordships, I am appearing in item 21.34. If your Lordships allow for Re-Neet, we are covered. But if your Lordships do not allow for Re-Neet, your Lordships, our relief is restricted to seeking parity with 1563 students. Your Lordships, we are the tribal students from Meghalaya who appeared from two centers, Riboi and Jowai. So, your Lordships, admittedly, there has been loss of time as apparent from the representations made by the center coordinators and also admitted by the NTA. Your Lordships, that has been also admitted by NTA in their response dated 17th of July.
Extra time for that. That's your individual grievance in regard to the Meghalaya student.
Please, Your Lordships, and
See what we do on that.
please, Your Lordship.
Your Lordship, in case there is no Re-Neet, I would pray that if the answer, option number 4 is considered to be only correct answer, I would expect only if the
My lord, I'm in item number 24. It is on a completely different tangent. Since 2020, before the Delhi High Court, we have been agitating that the NTA officials are involved in the swapping of my OMR sheets. My lord, in the digital.
All right, we'll deal with your case.
My lords, I am also here with the same grievance. When the NTA answer sheet was released, I scored almost 509 marks. I had attempted 131 questions. And when the final result came out, I scored -6, which was very shocking
My
for
lord,
me.
interestingly, the Delhi High Court had confiscated the OMR.
All good things.
Also, my lord,
At the blood, since this is the end of the hearing.
Mr. Solicitor, now, have you constituted a committee or something like that?
We have.
Now, what,
Yes.
give us some idea about that.
We have. I'm sorry, my lord. I should have pointed that out, my lord. There is a 7-member committee, my lord. It's subject to your lordship's approval. It is. Yes. But it is R21 of the counter affidavit, page number.
R21 of the counter affidavit.
Yes, my lord. It is headed by Dr. K. Radhakrishnan, former chairman ISRO and chairman Board of Governance, IIT Kanpur. Then Dr. Randeep Guleria, former director AIMS Delhi. Professor B.J. Rao, Vice Chancellor, Central University of Hyderabad. Professor Ramamurthy K., Professor Emeritus, Department of Civil Engineering, IIT Madras. Shri Pankaj Bansal, co-founder, People Strong and board member of Karma Yogi Bharat. Professor Aditya Mittal, Dean, Student Affairs, IIT Delhi. Shri Govind Jaiswal, Joint Secretary, Ministry of Education, as a member secretary. Lord, it is placed at R21 with my counter, my lord, counter dated.
July.
4th July.
Return after 5 minutes.
Please. Lord, on the, since at the end of the day, on a lighter note, sometimes your lordships must be missing the virtual hearings where there is a facility of muting us.
We'll be back in 5 minutes. Dr. Sikri has something, Mr. Paul? So after we come back after 5 minutes, all right. Then just come back after 5 minutes. Just take a break.